Hello everyone, welcome to our channel. This is a Posh at Work presentation of legal insights on important issues surrounding sexual harassment and related matters. Posh at Work is a boutique firm which assists organizations across sectors in complying with the law against sexual harassment at workplace and related matters pan-India. My name is Sania Tarwar. The judgment in the spotlight today is Abhilasha Dwivedi versus Department of Women and Child Development (NCT) by a Delhi High Court decision dated November 19, 2019. The judgment threw light on several aspects, and as we move on, we will discuss the following conclusions of this particular judgment. Constitution and composition of the internal committee and who can be on the committee. Definition of sexual harassment under law and what may be called a sexual harassment complaint. Ex parte hearing and how inquiry takes place when a party is absent or missing or even absconding. Transfer of employees. Before we discuss these aspects, let's look at the facts that led to this judgment eventually. The complainant in this case was working as a clinical psychologist and mental health professional at an NGO. The NGO was engaged in working with an observation home for boys. Complainant was required to counsel the residents of the observation home. Respondent in this case was the superintendent of the observation home. On January 2019, complainant filed a complaint against respondent with Delhi Commission for Women on January 10, 2019. She also uploaded her complaint on the SheBox, which is an online portal maintained by the Ministry of Women and Child Development. SheBox is an online portal for registration of complaints of sexual harassment. This is run by the Ministry of Women and Child Development, Government of India. We have also provided the link to SheBox in the description below. On March 30th, 2019, she received an email informing her that she had been transferred to Alipur office and was required to report there. On April 24, 2019, she received an email informing her that an internal committee had been constituted. Before we move forward, let us understand what the internal committee is. Now, the law under which this is constituted is called the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Section 4 of this law states that any organization that has more than 10 employees must constitute a committee called as Internal Committee, or commonly known as IC or ICC. The role of this committee is to inquire into complaints of sexual harassment. This committee should have a minimum of 4 members as per law. A presiding officer who is a senior level woman employee, 2 more employees of the organization itself. On the same day, she received a notice calling her to be present for a hearing. On April 28, 2019, she received an email from the committee stating that we will not help you. On May 6, 2019, she received an email from the committee giving her a final opportunity to appear before the committee. It also said that if she would not appear, the committee will look into the matter ex parte. So what does the word ex parte mean? It means hearing one side only. As per Rule 7.5 of the law, IC can conduct an inquiry ex parte or terminate complaint if a party is absent or missing or absconding after giving sufficient notice. Then she filed a petition before the Delhi High Court. In her petition to the court, she stated that respondent would change his clothes in the presence of female staff. This caused harm, discomfort and embarrassment to them. He would also ask her to accompany him wherever he was going. He would make her stand and other female staff sit in his chamber even if there was no work. He would stare at her and make her feel uncomfortable. He would also indulge in vulgar conversations. In her petition to the court, she mentioned that on April 7, 2019, respondent abused and threatened her to the extent that she was left scarred and traumatized. And as a result of this, she filed the complaint with Delhi Commission for Women and uploaded her complaint on the She-Box. Please note that the complaint she filed with the Delhi Commission for Women on January 8, 2019 did not mention the allegations. She mentioned to the court in her petition. So in her petition to the court, she argued that she did not have any confidence on the committee as the presiding officer was a colleague of the respondent. She had received an email from the committee stating, "We cannot help you," and this also led to lack of confidence. She was transferred, and this indicated that the department was biased against her. She asked the court that a new independent committee look into her complaint, her transfer order be quashed, she be compensated for harassment and for not completing her inquiry in 3 months as per law. After hearing the petition, the Delhi High Court held separately on each point. On constitution and composition of the internal committee, it said that the committee was not constituted to deal with any specific complaint, but to consider all complaints of sexual harassment within the organization. There is no reason to doubt the integrity or the independence of the committee merely because the presiding officer was a colleague of the respondent. This is an internal committee and is bound to include internal members from the department. Committee has 4 members and there is no ground to doubt the independence of the other 3 members. There is nothing to even remotely suggest that the committee was biased. On the email of the committee stating, "We cannot help you," the court said, it was explained that the email had been sent inadvertently and that a similar message had been sent randomly or automatically to all email addresses in the system itself. Copies of such messages had also been forwarded to the complainant. The court also observed that the complainant was assured by the committee that her complaint would be inquired into. Thus, any apprehension regarding the inadvertent email is needless. On ex parte hearing, the court observed that the committee had held hearings to examine the complaint on 5 occasions, but the complainant had failed to appear before the committee at any of them. On sexual harassment related allegations of the complainant in the petition before the court noted that certain allegations of inappropriate behavior which were stated in the petition did not find mention in her complaint filed on January 8, 2019 with Delhi Commission for Women. The complaint only alleged that respondent had scolded the complainant in front of 15 other persons. That complaint did not contain any allegation that respondent used to change his clothes in front of her or mention any of the other inappropriate misbehavior as mentioned in the petition. Therefore, court said that it is difficult to accept that shouting at the complainant itself in anger by itself can be considered as sexual harassment. For this, it also referred to section 2(n) of the law. On her transfer, the court said that how an organization deploys human resources available to it is a matter of internal management and does not merit interference by the court. This judgment is very important from 2 aspects. Firstly, from the point of view of constitution of a committee. Often, as practitioners, we see that parties feel that committee members may be biased in favoring the other side. This may only be natural because the parties and committee members may be working together and may also know each other for several years in some cases, in fact. However, the important point, as also stated by the Delhi High Court in this judgment, is that committee is an internal committee and will definitely have members who are internal members of the organization, that is, the employees of the organization. Therefore, it will be important for parties to note that merely being in the same department will not automatically mean that the committee member is biased. There will have to be some more evidence or material required to showcase that a committee member is biased. Also, in situations like these, the external member's role may become very prominent. So, if any member is actually being biased, the external member, being an independent and neutral member, can bring this bias to light. Secondly, from the point of view of the details that a sexual harassment complaint should contain, in this case, the complaint was immediately uploaded by the complainant on the box, which is for filing sexual harassment complaints only. This shows that the complainant was perhaps clear from the beginning that what has made her feel uncomfortable is sexually harassing, but she did not mention the details in the complaint itself. Because the first complaint did not contain all the allegations related to inappropriate behavior of the respondent, the court refused to further see into the matter and has also not taken into consideration the fact that the complaint was uploaded on SheDocs. Had the complaint provided all the allegations, perhaps the court would have decided differently. If you found this information helpful, please like our video and subscribe to our channel for regular updates. In case you have any queries about the law or our services or want any assistance, please visit our official website www.poshatwork.com or contact us. All links and other details are provided in the description below.